time, the defense calls Dr. Tatum Scher to the witness stand. May I proceed?
You may.
Good afternoon, doctor.
Good afternoon.
Could you introduce yourself to the jury?
Certainly. Good afternoon. My name is Dr. Tatum Scher.
What's your educational background, doctor?
I received my undergraduate degree in psychology from Columbia University. After that, I went down to Virginia at UVA for my PhD in cognitive psychology.
Within the field of psychology, do you have any specific focus?
Yes, both my teaching, currently a professor, and my research is in the area of eyewitness reliability.
Have you ever published research on eyewitness reliability?
Yes, I have. About 50 articles. I also lecture professionally on eyewitness reliability.
Have you ever testified in court about eyewitness reliability?
Yes, sir, I have.
And doctor, for today's case, what specific evidence did you analyze?
I looked at the statement, affidavit of an eyewitness, Mr. Emery Winkle. I also looked at several factors that I believe both parties had agreed to. And then I looked at several documents and a necklace, so the exhibits in the trial.
Doctor, is this the type of evidence that's regularly relied upon in your field?
Yes, it is.
Are the methods you use when you analyze these pieces of evidence the ones that are regularly relied upon in your field?
Yes, same methods used by other eyewitness experts, same methods I've used in my other cases, and that I teach currently.
And doctor, I just want to get this out of the way early. Were you compensated for your time here today?
Yes, I was. My standard rate.
Your Honor, at this time, the defense tenders this witness as an expert in the field of eyewitness reliability.
Ms. Snell?
No objection.
The court accepts this witness' credentials as an expert in that field. You may proceed.
Yes, Your Honor. Oh, doctor, what were you retained to analyze specifically in this case?
I was hired by Detective Jones to analyze the credibility and reliability of Mr. Emery Winkle's statement.
Did you put your conclusions into any sort of report?
Yes, as I do in all of my cases, I used my research, looked at the documents, and then compiled an expert report, which I submitted to both parties.
Your Honor, let the record reflect that I'm handing opposing counsel a copy of this expert report.
The record will so reflect.
Would Your Honor like a copy?
Are you going to use that? Are you going to offer that as evidence?
Yes, Your
I
Honor.
would like a copy.
Permission to approach the bench?
Yes.
And permission to approach the witness.
That's fine.
Doctor, I'm now handing you a copy of what has been marked as your expert report. Do you recognize that?
Yes, I do.
Is that truthful and accurate?
Yes, it is.
Your Honor, at this time, the defense offers this expert report into evidence.
Ms. Snell?
No objection, Your Honor.
Documents admitted. This is, we'll call this Exhibit 10.
Yes, Your Honor. Oh, Doctor, there are two overarching issues I want to discuss with you today.
Sure.
Mr. Winkle's wrong identification in 2003 and his account of conversations with Detective Jones in 2003. Does that sound good to you?
Certainly.
All right, well, let's start with that first point. Mr. Winkle's wrong ID in 2003. In your expert opinion, is there a reason for that wrong ID other than coercion?
Of course. The most likely explanation is a case
Objection. This evidence, or this is improper expert testimony under Rule 704B.
Can you repeat the exact question you asked, Mr. Parker?
I asked, is there a logical reason other than coercion for this witness's wrong ID?
Can you explain the basis of your objection, Ms. Snell?
Yes, Your Honor. Coercion has to do with the defendant's intent in this case, which is the second element of witness tampering. 704B states that experts, even though they can speculate within their own field, cannot testify to the state of mind of the defendant on an ultimate issue.
I'm not sure the question as phrased necessarily gets into the mental state of the accused. However, I'm going to urge the defense to proceed with caution. Make sure that this is limited to conclusions the witness can draw and not something within the province of the jury. I'm going to allow the witness to talk about standards for reliability and consistency, but the witness is not going to be allowed to opine as to whether or not there was coercion in this case.
Yes, Your Honor.
So you're good so far, but you can proceed.
Yes, Your Honor. Your Honor, let the record reflect that I'm, for permission to approach the witness with what has been entered into evidence as Exhibit 1.
That's fine.
Doctor, I'm now handing you what has been entered into evidence as Exhibit 1. Do you recognize that?
Yes, this is a trial transcript that I reviewed in coming to my conclusions.
Now, on page 3 of that transcript, on line 25, how confidently does Mr. Winkle state that Matthew Reese was the killer?
He says, 100% as sure as I am of anything.
Doctor, what factors could lead someone to be mistaken about something that they sound so confident about?
Well, I think it's important to remember that just because someone is certain of something doesn't mean that their memory of that event is actually accurate. There are a number of factors that can influence the reliability of that memory, especially if there has been time since the event occurred, if there was a significant amount of stress during the event, and then how clear a view the witness had of the event, whether or not it was obstructed, distance, lighting, etc.
And were the conditions in this case consistent with a witness potentially making a wrong identification?
Yes, they were. It was a dark night. There were no lights except for, I believe, a bonfire, and it was from a significant distance, anywhere from 50 to 100 feet on a poorly lit beach.
Doctor, in your expert report, I also believe you talk about something called unconscious transference. I was wondering if you could explain that to the jury.
Sure. Unconscious transference is a fancy way of saying mistaken identity. An individual observes an event. They see someone maybe they don't recognize but fits certain characteristics, and then down the road they'll see a second individual who matches that description, and they'll unconsciously transfer that person into the original memory. So even though that person was never there, they now remember them being there.
So, Doctor, given the specific circumstances and this idea of unconscious transference, do you believe, in your expert opinion, that it's reasonable that in a situation like the one we have today, there could be a wrong ID on May 1st?
Certainly. It's a reasonable explanation for why Mr. Winkle identified Mr. Reese as the individual on the beach. He saw someone of average build, height, hair color, and then later was shown a photograph of someone with a similar physical description. He unconsciously transferred that photograph into the memory.
All right, Doctor, in that case, I'd like to move on to my second point. Mr. Winkle's recollection of interactions with Detective Jones. In your expert opinion, is his recollection reliable?
No.
Doctor, in your expert opinion, is it reasonable, given the factors, that Mr. Winkle could be fabricating these conversations?
Yes, it is a reasonable explanation.
Oh, Doctor, did you review Emery Winkle's affidavit?
Yes, I reviewed both his affidavit and his testimony from the 2003 trial.
In that affidavit, written in 2016, did you notice any substantial quotes from 2003?
Yes, what I noticed was that even though it was 2016, Mr. Winkle had very accurate recollection of what Officer Jones allegedly told him, to the point where he was giving specific quotations. He said exactly this to me in 2003. That raised my eyebrows, certainly.
Well, why did that confuse you?
Well, there was a conflict between the details Mr. Winkle couldn't remember. He made a series of, in his affidavit, he contradicted testimony he gave in 2003, yet he was so certain of these quotes, word for word, given to him 16 years ago.
So, Doctor, given that discrepancy, do you find Mr. Winkle's account of coercion reliable?
No.
Thank you, Doctor. Your Honor, no further questions at this time.
Thank you, counsel. Ms. Snell.
Yes, Your Honor. Good afternoon, Dr. Scher.
Good afternoon.
Now, in your expert report, which is now admitted into evidence, you list 4 factors that influence witness testimony. But on direct examination, you only testified to 3 of those 4. I'm going to ask you about the factor you didn't tell the jury, law enforcement techniques. You agree that when an officer has previously investigated a suspect, that officer can be more likely to coerce a witness into testifying against that suspect?
Intentionally or unintentionally?
You considered that the defendant arrested Matthew Reese in 2000 for allegedly assaulting a woman?
I did.
That case was dismissed.
Correct.
You considered that the defendant arrested Matthew Reese in 2001 for allegedly stealing a gun?
Yes, I consider the fact that Detective Jones had 3 times previously arrested Mr. Reese. All 3 times charges were dismissed.
That's right, and the 3rd time the defendant arrested Mr. Reese, it was for assaulting the defendant himself, wasn't it?
That's correct.
So you'd agree Matthew Reese was a past suspect of the defendant?
That's what it looks like, yes.
Now I want to talk about the ways law enforcement officers can influence a witness's memory.
Sure.
On direct examination, you said that Ms. Winkle could have misidentified the two because she was shown a single photo, right?
Right, and that's the unconscious transference I was discussing.
Now, you agree that when an officer shows a witness only one photo, that strongly suggests that the suspect in that photo is the culprit.
Right, but it's unclear in this case if that's actually what happened, if Mr. Winkle was shown one photograph or a photo array with a number of pictures.
But Dr. Scher, if that didn't happen, doesn't that make unconscious transference less likely?
If what didn't happen?
If the defendant didn't show Mr. Winkle this photo, that makes your claim that there was an unconscious transfer less likely, doesn't it?
To be clear, I didn't conclude there was unconscious transference. I concluded that is a strong possibility given the evidence in this case.
And just to be clear, that possibility wouldn't be as strong if the defendant hadn't shown Mr. Winkle this photo.
That's correct, yes.
Now, I'd also like to talk about how witnesses tend to trust police officers.
Sure.
Now, in your experience, witnesses tend to believe that officers are only trying to catch a guilty person, right?
That's correct.
This makes witnesses more susceptible when officers feed them false information.
Right. In fact, even if officers aren't feeding false information, if it's they're simply more gung-ho about pursuing a suspect, individuals will be more likely to believe them because we naturally tend to trust police officers.
And according to Ms. Winkle, the defendant told her Mr. Reese was convicted of 3 previous crimes, right?
Yes, that is what Mr. Winkle claims.
You're aware, based on Exhibit 3, Mr. Reese was never convicted of any crime until 2003?
Right. Again, all the charges were dismissed.
So the defendant lied?
I don't know whether Detective Jones lied because I don't know if Mr. Winkle's testimony is accurate.
All right. And it's Mr. Winkle's testimony that the defendant told him Karen Turner's necklace was found in Matthew Reese's tent, right?
Yes, according to Mr. Winkle's statement.
And you're aware, based on Exhibit 7, that that necklace was found around Karen Turner's neck?
Correct.
So the defendant lied about the necklace?
Same answer as before, ma'am. I can't conclude one way or the other whether Detective Jones lied because I don't know if Mr. Winkle's testimony is accurate.
All right, let's talk some more about the exhibits in this case. You agree Exhibit 7 corroborates the fact that Karen Turner's necklace wasn't found in Matthew Reese's tent?
That's correct.
You agree Exhibit 9 corroborates Ms. Winkle's testimony that the defendant might have been trying to cover up wrongdoing?
That's correct.
And let's talk about Exhibit 6. Now, this exhibit, Your Honor, may I approach the witness?
Excuse me?
May I approach the witness?
Yes.
And may the record reflect that I'm showing Exhibit 6 to opposing counsel?
Yes?
This exhibit was written by the defendant, true?
Which exhibit is that, ma'am?
Objection, Your Honor. I'd ask that before we go into the specifics of the exhibit, it be entered into evidence.
Yes, Your Honor, I can lay foundation.
Okay, maybe I think the question is just who wrote it, so we haven't gone into content yet. So we're in the clear. Why don't you present that to the witness?
Now, you recognize this, right?
Yes, I do.
This is the police report you reviewed for this case?
Correct.
Your Honor, the people offer Exhibit 6 into evidence.
Your Honor, we do have an objection as to a second-level hearsay in this exhibit.
Hearsay within hearsay?
Yes, Your Honor.
Can I see a copy of the exhibit?
Yes, Your Honor. Oh, may I approach?
Yes, please. Do you have your own copy to look at, Ms. Snell?
Yes.
Great. Wait until Ms. Snell is ready.
Yes, Your Honor.
Mr. Parker?
Yes, Your Honor. Although fundamentally this exhibit was written by Detective Parker Jones and that would fall under admission by party opponent. There are statements in there from both Emery Winkle and the medical examiner, Elizabeth Bays. Both of those statements are hearsay at a second level and are inadmissible.
What are those statements?
The statement from Elizabeth Bays about
This is cause of death?
Yes, Your Honor.
And what else?
The Emery Winkle statements about his recollection of what happened on May 2nd and May 4th.
Okay. How do you respond, Ms. Snell?
Your Honor, this exhibit is not being offered for the truth of the matter asserted. In fact, the people are offering this exhibit to show that the defendant, that certain facts in it aren't true. Those statements that opposing counsel mentioned specifically will never be brought up by the people. And furthermore, those statements wouldn't be used for the truth of them.
Okay. With that caveat, is the defense comfortable with this exhibit?
Yes, Your Honor, if they're not being offered for the truth of the matter asserted.
Great. Sounds like everybody's on the same page. Exhibit 6 is in. Proceed. Do you want this in the hands of the witness?
Yes, Your Honor.
Thank you.
Actually, do you mind if I grab that before
Go
continuing?
ahead.
Your Honor, may I publish Exhibit 6 to the jury?
Yes.
Now, you're aware the defendant wrote this report,
Yes, that is correct.
and it's supposed to include the process of his investigation.
I can't tell you what police reports are supposed to include.
All right, but before we talk any more about that report, let's talk about the stipulations.
Sure.
Stipulation A is that the necklace Emery Winkle gave the FBI had the fingerprints of Karen Turner, the defendant, and Emery Winkle, right?
Yes.
This corroborates Mr. Winkle's testimony that the defendant gave her Karen Turner's necklace on May 3rd.
That's correct.
And stipulation 7 is that when the FBI went to find that necklace in the evidence bag where it was supposed to be, it wasn't there.
Yes, that's correct.
This also corroborates Mr. Winkle's testimony that the defendant gave him Karen Turner's necklace on May 3rd.
Right. It corroborates it. It doesn't confirm it.
Now let's go back to this report. This report written by the defendant has no record of a conversation occurring on May 3rd, does it?
I'll have to see it, ma'am, but I'll take your word for it.
This report has no conversation of the defendant giving Mr. Winkle a necklace?
Your Honor, I'd ask that if opposing counsel is going to ask this witness about the contents of the report, the witness be provided with a copy so he can answer honestly.
Yes, sir.
I think this witness said he reviewed the document previously, no?
Your Honor, he did, but he also just said last question that in order to confirm opposing counsel's question, he'd like to see it in front of him.
Well, he's free to say he doesn't know. I'm going to let counsel conduct her cross as she wishes, but the witness can continue to say that he needs to see it. So that's up to Ms. Snell. You can proceed.
Here you go, Dr. Scher. Now,
Thank
just
you.
to be clear, this report doesn't include any May 3rd conversation?
No, it does not.
Doesn't include the fact that the defendant gave Mr. Winkle the necklace?
No, it does not.
And just to be clear, in your opinion, the totality of the exhibits tend to corroborate Mr. Winkle's testimony, right?
Yes, again, corroborate, not confirm.
But I want to make it clear to the jury, your opinion is still that the defendant only may have intentionally influenced Mr. Winkle?
It's one of several possibilities.
All right, Dr. Scher, let's talk about why you're here.
Sure.
The defense paid you $12,600 to write your report.
Yes, I was compensated for my time.
They paid you another $5,000 to testify today.
Yes, ma'am.
Thank you, Dr. Scher. Your Honor, nothing further at this time.
Is there a redirect examination?
Yes, Your Honor. Before I proceed, I'd request a time check.
Absolutely.
For a redirect examination, the defense has 1 minute and 13 seconds.
Thank you. May I proceed?
Yes.
Doctor, on cross-examination, when opposing counsel asks you about the exhibits, you use the phrase corroborate but not confirm. Could you explain that to the jury?
Certainly. The statements by Mr. Winkle and the exhibits I looked at are consistent with Mr. Winkle's story. That doesn't mean Mr. Winkle's story is accurate. They're also consistent or corroborate several other possible explanations. That there was unintentional suggestion to Mr. Winkle, or that Mr. Winkle himself fabricated the story. It's consistent with all three explanations.
And doctor, did the fact that you were paid for your time influence your testimony in any way today?
No, again, I charged my standard rate.
Thank you, doctor. Your Honor, no further questions.
Thank you, counsel. Ms. Snell, is there any further examination?
Yes, Your Honor.
You may proceed.
May I inquire as to time?
Yes.
people have 2 minutes and 23 seconds for recross.
All right. Just one last question.
Sure.
Dr. Scher, to be clear, you wouldn't be here today if you weren't paid, would you?
Again, I take time away from school and research. I expect to be compensated for that time.